For some analysis on this, I'm now joined by legal analyst Mpumelelo Zikalala. Mpumelelo, a very good morning to you. Thanks for joining us. Welcome to the agenda.
Good morning to you and good morning to your listeners and viewers.
Former President Jacob Zuma's trial is back in court today. What can we expect to come out of today's proceedings?
Well, you can almost call it a trial within a trial within a trial. The first question that will be answered by the court is whether these proceedings can proceed using virtual platforms, as stated earlier. Remember, President Zuma is saying, I want to go to court and give viva voce evidence. I want to go on the witness stands and give evidence in addition to whatever that has been given either by affidavit. Now, that's going to be a bit of a challenge if you're conducting a trial within a virtual platform. Currently, the Criminal Procedure Act, which is basically our manual that tells you how to conduct a trial in a free and fair manner, only allows virtual sittings or circuit evidence giving for only sexual offences cases, not for hardcore criminal matters such as these ones. So we may see this particular application succeeding if his team is going to say, we want to go to court and make sure that he's put on the witness stand. He has evidence that he wants his court to give. Now, the other side of the NPA will then say, how valuable is this particular evidence? Because all that you are fighting about here is pure legal principles and administrative patterns. It is nothing that there's nothing that you can provide further other than what is available and what you have to post to an affidavit. So you are engaging in delaying tactics and you want to get this trial moving as soon as possible.
Well, his legal team does not want the trial to be heard virtually. Isn't it bizarre that his rescission and stay of execution of arrest cases recently were heard virtually and they never protested? So take us through the legalities, or rather the basis of the former President Jacob Zuma asking for his trial to be postponed for a week.
We have to distinguish between the type of evidence that is going to be led at this particular, in this instance. Remember, on those two bases, it was only the legal representations or the legal representatives that made submissions. So there was nothing which came from the former president. He was not put in the witness box. He was not asked to swear his allegiance to tell the whole truth and nothing but the truth. So it was purely on affidavit, the evidence which was being dealt with by the court. Now, in this instance, what the team is saying, you want him to go into the witness box. You can then engage in the normal processes in the way in which we would when doing it virtually. We would want to cross-examine him. The court will want to check his demeanor when he's giving evidence and all the other factors which regulate the law of evidence and the procedures that have been done in court, and that can't be achieved when it comes to criminal matters. But most importantly, because we are dealing with a criminal case, you have to do whatever is allowed or permissible as per the Criminal Procedure Act. Currently, it does not allow unless if you want to extend it as the Pietermaritzburg High Court, since you have inherent jurisdiction. So the difference between the two is who is going to give evidence and who is going to talk to the court this time. In previous occasions, legal representative, it's fine. But in this instance, his team is saying we want him to go into the witness box and we can't be able to achieve that effectively if we do it virtually.
Now, Tali's legal team had contended that the prosecution had actually failed to sort of give a summary of available and admissible evidence when formulating the charges for racketeering, corruption and money laundering, and instead simply alleged that such existed. Therefore, the legality principles were violated, they argue, because there was nothing to support a reasonable belief implicating Talis in racketeering, leaving the National Director of Public Prosecutions. So, in what sense, though, Mpumelelo? Like, in what sense is the true? What are your thoughts on this?
But on that one, if they have that particular challenge, you always have the courts to come back to at the end of the day. When you're an accused, you simply sit there and wait for the evidence which is alleged to be against you to come to you. You don't go to it, and you're not obliged to talk. Remember, you have the right to remain silent as protected by the Constitution, meaning, if you accuse me of doing something, take me to court, yes, but I'm going to keep quiet and only dispute the evidence in which you are going to bring to the fore. At the end of the state case, we have Section 174, which then allows you to say, at the end of the day, the case has closed its case, and on all the elements which are supposed to be proved, they fail to prove my criminality or my liability in terms of this matter. So can you please strike it off the roll and make sure that you find me not guilty? So that particular option is still available to Talis. So for them to fight about this issue at this early stage is certainly not going to help, and it has no bearing on the matter whatsoever. I don't see the court saying that this trial cannot start because you haven't been provided the information. If there's an indictment which is sufficiently drafted to know that what type of charges are you facing at court, that should be sufficient. Everything else, leave it up to the witnesses. If the witnesses are credible, you will cross-examine them and deal with the evidence back then. If there's been no evidence that has been proved at the end of the state case, you have section 174 to deal with, and that will be able to exonerate you.
Yeah, and just picking up on that point, another argument is also made that there was no facts to show that the money flow upon which the trial is rested were actually the proceeds of crime. And I suppose that is the basis of the contestation that former President Jacob Zuma has been making since the start of his political and legal woes, that he's ready to take the fall only if somebody comes up with concrete evidence.
But the NPA can then come back and say, allow us to give you that opportunity. There is a person who will be able to give viva voce evidence, will be able to say, this was the true intention of the transactions. This is why these transactions took place in this particular manner, and that is why you then had a third party which managed the whole process. We can't do that preliminary. We need to go to court to ventilate all those issues and make sure that you're able to answer them. But remember, there's a second leg or sort of an alternative charge that is of not disclosing at SARS and not disclosing in Parliament, which then will be the second, or maybe let's call it the second and the third price of saying, because we failed to prove corruption and racketeering in that particular sense, let us at least hold you accountable in terms of not being able to disclose in Parliament and not being able to disclose that particular income when it came to SARS. So you are dealing with the swords which is triple-edged, if you would call it like that. But the most important thing is this: if you are then called to court, it is the perfect arena for whatever evidence to be discussed. It is the perfect arena for all the evidence to be ventilated, to be given the full scope of what is going to be said. It's a bit sort of unfair on the state. Go to court and answer then, and then you'll be satisfied.
All right, Mpumelelo Zikalala, great chatting to you. Thank you so much for your analysis.
Thank you very much. Enjoy your case.